The Director, Legislative Support Service, National Institute for Legislative and Democratic Studies, has called for the establishment of an appellate chamber of the ECOWAS Community Court of Justice. He made the call in Abuja during the opening ceremony of the 2019 to 2020 legal year of the ECOWAS Community Court of Justice with the theme, "The Need for a Strong and Independent Regional Court for the Economic Integration of West Africa." He explained that the second phase should pilot the affairs of the community in the context of investment, trade and competition, as well as harmonizing business laws.
It is in the best interest of all of us that the appellate chamber of the court is created in a very urgent manner. And the reason actually is simple. A right of appeal is indeed a fundamental right. Your Excellencies, the right of appeal that is non-existent today in the court is a fundamental right of the community citizens, which is part of the cardinal principles of the ECOWAS Actual Revised Treaty. So the court is not asking ECOWAS Commission and the ECOWAS member state to do it a favor. It is rather promoting what member states have already actually agreed on as part of their cardinal principles in the revised ECOWAS Treaty, for it actually to move the entire West African sub-region, forward. So what the court needs now is that it has already drafted an organogram reviewing its structure. It needs the support of the ECOWAS Commission, member states, and also the ECOWAS Judicial Council to support the implementation faithfully of this organogram. This is odd, given ECOWAS' broad economic integration objectives and programs since 1975 and the court's powers since 2001, and yet it is little known outside its human rights jurisprudence and success story. In my view, the ECOWAS Court of Justice has the potential of serving as a forum or tribunal for the settlement of at least some disputes between foreign investors and host member states. The ECOWAS Court of Justice power to act as a community arbitration tribunal is yet to be functionally activated or triggered. It's in the law that the ECOWAS Court of Justice can, in the absence of an an arbitration tribunal, can for now serve as an arbitration tribunal. But for over 2 decades, this particular clause has not been triggered to test the court before it can be tested as an investment, and trade tribunal.
President of the Nigerian Bar Association, Mr. Paul Usoro-San, reiterated the call for the establishment of an appeal chamber of the ECCJ. Represented by another son, Mr. Ofiong, Usoro said it was worrisome that judgment passed in the court could not be appealed.
The independence of the CCJ is no doubt an indispensable ingredient if we must achieve the desired economic integration. Apart from being independent in hearing and determining matters brought before the court, it is worthy to mention that the CCJ cannot be truly independent if the court does not have absolute budgetary control and freedom to choose its members.
The court's registrar listed some of the challenges of the ECCJ to include reduction of the numbers of judges from 7 to 5.
It is also of great concern that the tenure of judges was reduced from 5 years in able to 4 years long ago, and that the tenure of the members of the court is no longer staggered as was envisaged under the 1991 protocol on the court. Another major challenge that the court is serving is the reduction of the number of translators from 9 to 6 in the 2018 organogram of the court. Another concern of the court is the problem of enforcement of its judgments. Although the judgments of the court are binding on member states, institutions, individuals, and corporate bodies, the level of compliance or enforcement of the judgment of the court is worrisome.